Hello friends, welcome. Friends, today morning I saw this article in Business Standard. Which says that Supreme Court agrees to listen to Vodafone Idea's plea on AGR computation. And now there is some background also which has been written in this article. Anybody can go and read this. And whoever understands the telecom sector, has followed the telecom sector from the beginning, will understand that how important this issue is. And this issue we can create a huge advantage to Vodafone Idea as well as to Bharti, who has a lot of outflows, commitments to the government as regards AGR dues are concerned. So if you look at the numbers are also mentioned here in this article. Vodafone Idea's total liability was, let me just take my pen again, was rupees 58,254. Bharti Airtel's total liability was 43,980. The top court has given the telecom companies 10 years to clear their outstanding dues to the government right? So this is just today 16th, and it was basically published 15th of July 2024. Now friends, why I am doing this video? So it is very important for people to understand that there is no point in doing this and debating this issue right now when so much has been already discussed in past. Now friends, reason I am doing this video is that earlier, 8 months back, I had recorded 2 videos. And this video was just to give some kind of insight or background to those people who want to understand this issue, because this is very crucial for the sector. So this was titled Unveiling the AGR Saga, Telecom's Turbulent Journey Through India's Legal Labyrinth, Part 1. So basically gives you the history, what happened in past. And then I recorded one more video which talked about the Supreme Court judgment, the AGR judgment, and the costly mistakes which were committed by the stakeholder. And in this video, I had mentioned that I will record the third video, which will focus specifically on the PSU issue, Public Sector Undertaking issue. And those people who have no understanding of the AGR issue, don't worry. I will take you through on a very high level so that you will understand what the implication of the PSU issue is all about and how it can play a very important role. And because this issue was not properly handled at that particular point of time, it resulted in some kind of discrepancy in the overall judgment and was also pointed out by TDSAT later. Nobody might have focused on this issue, but TDSAT had pointed out an inadvertent or a mistake which was committed by Supreme Court and gave respite to a company called NetMagic. And this might be sounding like Greek and Latin to many of the listeners. So what I will do is, let me just go step by step to unlock this whole story. Now before I unlock this story, I would like to point out that I have been following this AGR issue from the very, very beginning, and I have put out in my website a chronology till the final judgment 24th October 2019, when the SC decided that it overturned the TDSAT judgment, which was in favor of the operators, established that DOT has the right to collect revenue from non-license activity, which is basically, if you recall, that the license fee was charged on the total revenue of the operators, which included licensed and non-licensed activity. And the bone of contention of the operator was that the non-licensed activities should be excluded from the calculation of license fee, which was a percentage of revenue. And then it says the revenue is as per contract AS9 for accounting purpose, established DOT right to impose interest and penalties. So this was the main judgment. And then later there was another judgment which forced the operator and accounted for the amount of money their operators had to pay. And I'm going to take you through that judgment also. So let me just first take you through that judgment, which is very important for us to talk about first before I take you through. This is the judgment, and this judgment was dated, let me tell you what date it was. This judgment was dated 20, let me just tell you what is the date of the judgment. This is in my article. This judgment was September 1st, 2020. So this is the judgment. And what is the judgment? This judgment laid out the details and the calculations. What would be the amount to be paid by the various companies, Bharti, Idea, Cellular, Vodafone and all others. If you look at this number, 58,254, this is the number which Vodafone is supposed to pay. And so there are some money and calculations which were established. And according to this calculation, the companies were supposed to pay. Now, the reason I am kind of getting involved into this particular video, as I already told you in the beginning also of this, that what is the key issue which is going to be debated in the court of law as the discussion happens. The first main issue, as I pointed out in my article, which I am going to take you through, which I wrote on 10th of October 2023, and this, by the way, this is going to be very crucial article. So there are 2 or 3 important documents which you should be focused on. Don't read any other document because it will confuse you, because this issue is a very, very important and very, very complex issue. Read this article. This article is going to give you a very good insight. After this video, you will definitely understand this article, and then go to my webpage to look at the chronology and reference document if you need to. So there are 2 pages here, if you see. One is the chronology, which is here, and another is the AGR issues document, which have all listed out, because these are all going to get lost in the websites. You will not find them. It is all here in this till the NetMagic case, which is on 20th February 2022. So everything is updated here. You will get every insight of this issue and all reference point if you need to do a little bit more digging. So let's first go to the key issue, and I will go through this article because this article anchors all the activity and you will be able to understand the PSU issue better. Otherwise, it will be a very fractured discussion and it will not make any sense. The first thing to understand in this article is that, so what is the heading of this article? The heading of this article is examining the exclusion logic of PSUs and its parity with ISPs. So as you go through this article, you will understand that the PSUs, parity with ISPs, and the exclusion logic was not applicable to all PSUs across the board. Whatever logic the Supreme Court used to exclude PSUs from the burden of license fee, additional license fee to be paid as it was made applicable to the mobile operators, could not have been applied on a blanket basis to all the PSUs. And that led to a discrepancy and some kind of unfairness regarding the whole Supreme Court judgment is concerned. And you will understand that how this judgment was not properly structured, and if you read the judgment, you will find that this judgment had holes in the arguments, and that is the point of this discussion, which was noticed by TDSAT. So that is the main point. I am not saying it. TDSAT made a reference, and you will understand what this reference was, and that kind of linked to the fact that the judgment was not properly kind of argued, and the argument which was used was not applicable across the board, and there were certain errors. So let's go step by step. The first thing on the Vodafone case was the amount of money recoverable by the government of India based on certain calculation. So what the Supreme Court said in the judgment of September 1, 2020, this is the judgment, and if you go to this, you will find all the documents are linked here. So this is a very good thing about this article. All documents are linked, and you just click the link and you will get the reference. So in this document, you will go to the page number 4, and you will find that this is the heading of the calculation table, which says that amounts recoverable from major TSP as per preliminary assessment. Look at this word, preliminary. It is not final assessment. So whenever there is an assessment which takes place, DOT had laid out its own calculations to the mobile operator, saying that we believe as per DOT, this is the money you have to pay. So this is the judgment, right? If I go to the judgment, and I'll just have a look at the judgment for your own understanding and for my reference also. Where is the judgment? Here is the judgment, I think. I know this is 22nd. So this is the judgment. You will see that the amounts recoverable from major TSP and the numbers are all laid out here, which is a preliminary assessment. It is not a final assessment. So what the operators are now probably arguing before the court of law, that there are some calculation mistakes, and these calculation mistakes which the DOT has done has resulted in a blown out of proportion demand, which would get subdued to a very, very significant level if those errors were removed, because the errors would have resulted in a smaller principal amount, and since the penalties and interest were 4 to 5 times the principal amount, as you reduce the principal amount to a very small level or a small fraction, your interest and penalties numbers are also will shrink, and your overall requirement to pay to the government is also, your dues are also going to get reduced. So this is the main argument on which I think the review petition is going to be fought on. Now, I am not going to focus on this because I am going to give you the background of certain inconsistencies in the Supreme Court judgment. Then you will understand, I don't know what they did, why they came out with an inconsistent judgment and created such a big havoc for the industry. And let me point out some of the inconsistencies in the judgment. Now, what the Supreme Court said, the core rationale. Let's look at the core rationale argument. So here you will see that I am saying in this paragraph, the AGR case unpacking the core rationale. Well, what rationale was used by the Supreme Court. Now, what it is saying is the PSUs and the escalation, because if you recall, at the time when the judgment took place, Supreme Court judgment came, DOT actually went and put out a huge demand to the public sector units for payment, just like they did to the mobile operators. They said that public sector unit also have to pay huge amount of money. It was in lakhs of crores, right? And when the public sector were given the demand, they went to the court, and court became furious with the DOT official and said that this is incorrect. Whatever you are saying is incorrect, and the logic that they used was the following. They said that excluding the PSUs, the dissecting of the logic, and look at this logic, dissecting the SC's logic of excluding the PSUs. This is important. Now I'm going to read this para before you so that you will go word by word and you'll understand what is going on. The logic for excluding PSUs has been explained by the Supreme Court in his order dated 11th of June 2020, which I'm going to go through just now as I read through this particular para. A more important one is extracted from the judgment and pasted below for easy reference, and this is the 6th number clause, which says that it would appear from the text of the above definition. Means Supreme Court was describing the various license condition, and they said that this license condition has got this reference, this license condition has got this and that. I'm going to show you, right? Just before I show you, you should read this, because then only it will make a lot of sense. This particular para is very important. It would appear from the text of the above definition that the definition of revenue used in the USL ISP licenses as against the phrase used for the NLD IP2 licenses are different. So in nutshell, what Supreme Court is saying, the USL ISP license has got a different structure of definition of revenue, and the NLD IP2 license have got a different structure. So since many of the PSUs were holding NLD IP2 license, they could not be clubbed with the USL ISP license. Simple logic, which Supreme Court has said, and there is a definite logic Supreme Court has given on this. So I am not saying that Supreme Court was wrong in its interpretation when it says that NLD IP2 was different from USL ISP. But mind you, the word here, USL ISP, this will become very important. This is not USL alone. It included the word ISP. Means ISP category licenses were also part of the Supreme Court judgment of clubbing the revenue of non-telecom and telecom together for the purpose of calculation of license fees, whereas NLD IP2 licenses were excluded from that requirement of clubbing the non-telecom and the telecom revenue. This is very important. Mind you, just remember this, right? So, what the Supreme Court said, that NLD, ILD need not basically club, and therefore there was no requirement for them to pay the DOT demand, and DOT should take back the demand. Now, if you look at this table I have extracted from the Supreme Court's judgment of February 28, 2022. So now, if you look at this table, you will find that it lists all the PSUs which were in operation at that particular point of time. Like you see Oil India, Railtel Corporation, Power Grid, Software Technology Parks. So there are various PSUs, etc., including BSNL and MTNL were included. Now you'll find that most PSUs, some of the PSUs have NLD and IP2 licenses, which were clearly excluded because of the language where Supreme Court said. But some of the PSUs also had ISP license. For example, Railtel Corporation of India. Okay, and then there were some other also had ISU, like Tamil Nadu Arsu Cooperative. Some other also had ISP license. Gujarat Narmada Fertilizer, they have an ISP license, right? Now the point here is that Supreme Court made a very important logic. They said those PSUs which were holding ISP license, they were not holding the ISP license with the intent to do commercial business. This is important. They said that their purpose of holding the license were local to the requirement of their own company. They were not selling services just like the mobile operator holding the USL licenses were doing. That is why they excluded all the PSUs except for MTNL, BSNL, who were in commercial business of selling services. So apart from MTNL, BSNL, which were kind of to be paid, they were supposed to pay, and they had a demand from the government to pay the unpaid license fee, which included the non-telecom portion of the revenue, the license which is applicable to the non-telecom portion of the revenue. Rest of all the PSUs, with even those who are holding an ISP license, which were similar to that of the USL license, from the obligation of aggregating the telecom and the non-telecom portion of the revenue together, they were also excluded. So again, let me repeat for the sake of understanding. There were multiple type of licenses, and they were bucketed into 4 different categories: USL license, ISP license, NLD license, and IP2 license. NLD and IP2 license definition were different, and Supreme Court said what was the reason why those definitions were different, and they gave a logic, and they said that they do not fall under the obligation to include telecom and non-telecom portion of the revenue together, right? So they were excluded. I have no problems with that, because Supreme Court found an argument, which I will tell you what the argument was. There was no problem. However, Supreme Court said that the ISP and the USL licenses were at par from the definition of revenue is concerned, and therefore they had the obligation to be treated at par as they were required to be treated by the DOT for the purpose of clubbing license, for the purpose of clubbing non-telecom and telecom portion of the revenue together for the purpose of calculating license fees, right? Now, some of the PSUs were holding ISP license, but they were excluded from this obligation except MTNL, BSNL. Now the logic that the Supreme Court gave for excluding those PSUs like Railtel from this obligation is that they are not into commercial business of selling services. This is where they went wrong, and this is where the TDSAT judgment has come in. What happened was that there was a company called NetMagic. The NetMagic went into TDSAT because DOT levied a demand to NetMagic, though DOT excluded other PSUs who had an ISP license from the obligation to pay license fee, which is extra for the non-telecom portion of the revenue. But those who were private sector ISP license like NetMagic, they were placed a demand for including the non-telecom portion, because they also did not pay the non-telecom portion of their revenue, the license fee which is applicable to the non-telecom portion of the revenue. So they levied a demand to them, NetMagic, saying that you have to pay. So NetMagic became aggrieved. They went to TDSAT, and the TDSAT basically said that since you have excluded, if you look at the argument, the NetMagic argument was grounded in a clear logical premises which I have written. If the Department of Telecommunication, it says that if the Department of Telecommunication considers, so let me just put my pen again so that everybody can understand. If the Department of Telecommunication considers the Supreme Court judgment applicable to public sector unit, which include ISP as well, it should equally apply the same principle to the non-PSUs, which are private sector company. As a result, NetMagic firmly asserted that the DoT should be instructed to review its demand with the mandate to exclude non-telecom revenues from the calculation of license fee. TDSAT concurred with this sound reasoning and granted its approval to NetMagic petition against the respondent, which is DoT. You understand now what was the point? And therefore, and then TDSAT goes on to say, look at this. This is important. You will find it very, very interesting, and nobody actually has focused on this because this was largely, lost in the press. Nobody basically looked at this because nobody was interested. Now, TDSAT noted and corrected SC's mistake. This is important. TDSAT, I read out this because this is very important. TDSAT further identified and rectified an error made by the Supreme Court in its judgment dated June 11, 2020, where the preliminary calculation numbers were given. Supreme Court has based its decision on the premises that PSUs excluding BSNL MTNL were not engaged in any active business offering mobile services to the general public. In this context, clause 29, page 26 of the TDSAT judgment is presented below for your reference. Now, what is TDSAT saying in this 29 page number 29? TDSAT is saying that the observation of Supreme Court, the observation of Honorable Supreme Court in the order dated 11th June 2020, that even otherwise the public sector undertaking are not in actual business for providing mobile services to general public, was placed differently in the course of oral submission before the tribunal and accepted mistakenly as a finding of the Apex Court that the PSU are not providing license service to general public. You understand what is this issue? Now, what TDSAT is saying is that it was an oral submission made before the tribunal, this tribunal, and accepted mistakenly as the finding of Apex Court that the PSU are not providing license services to general public. Such error in order under review deserves to be corrected by reviewing that order on the basis of parity, equality, and level playing field for all licenses regardless of ownership. Right? Now, what I conclude in my article, and this is important to read, the summary of this article, the conclusion is very simple. In a summary, the Supreme Court employed two key rationale to exempt public sector undertaking from the Department of Telecommunication DoT's demand. First, it equated the USL license held by the mobile operators with the ISP license, distinguishing them from NLD IP2 license. Notably, only few PSUs were holding the latter set of license. However, DoT chose to exempt all PSUs from the requirement of combining telecom and non-telecom revenues from the calculation of license fees. TDSAT extended this exemption to the private internet service provider ISP as well, based on the principle of parity. This brings up the question of whether the same rationale should be applied to the USL licensees also, which shares similar language with the ISP license. If not, it could raise concern about the inconsistency, especially with some PSUs whose non-telecom revenues were excluded from the license fee calculation, were involved in the AGR dispute. So, what is your thought about this? Now, let me tell you, and then let's go to the Supreme Court judgment, which will give you a fair idea of what Supreme Court said. And this is crucial, and then I will close this. Now, if you look at this judgment, you will find that, and this is the judgment where Supreme Court became very mad at DOT. This judgment was dated, I think, June 11th. Let me just tell you what is the date of this judgment, because judgment date are always written below. It was never. This I find very, very strange in Supreme Court. You'll put the judgment date. I think the judgment date is not even listed below, but the judgment was. I'll tell you what is the date of the judgment. This is there in my chronology. And I think this is the judgment, 20th, 1st September 2020. No, I think this is the Supreme Court order, 11th June 2020. Let me click this, and then only you will be able to see whether this is it, right? So what was the judgment? The judgment was, if you look at the judgment, this judgment was, if I go here back, and you'll see this judgment was 11th June 2020. Now, if you go here 11 June 2020, you will find what Supreme Court is saying. Supreme Court is basically saying two important things. One is that it is saying that the definition of gross revenue for the USL is inclusive of installation charges, late fee, etc., and any other miscellaneous revenue without any setup. So that is one point Supreme Court is saying. Then Supreme Court, if you go, and for the ISP also the same language, any other miscellaneous revenue without any setup. But when it goes to the NLD and the IP2 license, this is important. Let me just go there in the NLD and the IP2 license. Yeah, here it is, the NLD and ISP license. It says that if you look at this line is important. It is basically saying the logic, why Supreme Court excluded the NLD and the IP2 license is saying that this is by way of providing services under the license. You understand? This is the line which the logic Supreme Court is using. And again, let me just read out this. That it would appear from the text above, the definition of the revenue used in the USL ISP license against the phrase used for the NLD IP2 license are different. This is Supreme Court saying, right, in this order. Specifically, the phrase by way of providing license by way of providing services under the license. It's saying that by way of providing service under the license. Rather than basically, so it is interpreting that this phrase, Supreme Court is interpreting that the non-telecom portion of the license, a non-telecom portion of the revenue will not get clubbed with the telecom portion because of this phrase by way of providing services under license. And this phrase is not written in the USL and the ISP license. Now, the ISP license holder, the PSU like Railtel, were already involved in commercial businesses, right? They were already providing services. And the Supreme Court, when it went on to say that the public sector undertaking, look at this line. It says, Supreme Court says in his order, and that's why it gives a kind of a respite to all public sector units which held even the ISP license. It says that even otherwise, the public sector undertaking are not in actual business for providing mobile services to general public. This is important. This is a statement which Supreme Court made in its order in that particular day of June 2020, which is factually incorrect because Railtel was already providing service to general public, and why Railtel should have been excluded for this obligation. You understand now the problem? So I think, friends, this is what I wanted to say. That this is a very important event. Just to summarize, this is a very important event which Supreme Court is hearing, Vodafone Idea and Bharti, and that will definitely lead to rationalization of the demand because of the calculations will get revised. But on the side, it is important to understand that the logic that Supreme Court used to exclude the ISPs from the burden of especially the PSU ISPs from the burden of aggregating telecom and non-telecom portion of the revenue and calculation of license fee on top of that was probably incorrect because the same logic does not apply to all the PSUs. Maybe the NLD and IP2 I can understand, and if it was applied, it should be applied to everybody, including the USL license provider also. The same logic should not have been, because this was an incorrect. If you give a judgment on the USL license provider who are selling services to the public, you should basically extend the same judgment to the ISP license provider also, whether it is PSU or non-PSU, who are giving services to the public, and then why RailTel was excluded from this obligation. Do you understand what the point is? Why I'm so aggrieved? Why I feel so pained about it? Because I remember Qualcomm. I was working for Qualcomm. DOT levied a demand of around 550 crores on Qualcomm when it was in the process of selling its licenses to Bharti. The ISP license which it bought, which is actually acquired when it bought Spectrum, and that we had to pay. Now look at this judgment. It was a payment of 550 crores of rupees to DOT, which was highly unreasonable. Now if you look at the judgment of Net Magic judgment, what TDSAT had said, it's highly irrational. And that happened in 2012, this judgment in 2020. It is so unfair. It is so unfair. Look at the way we are being public sector, private sector companies are treated, and the legal situation of the country is so distorted. And it is a matter of chance that somebody gets away. It's a matter of chance somebody does not get it. It should be more robust. The fairness has to be more robust in the inbuilt into the system. How can you apply a logic later when TDSAT figures out that you exclude the PSUs? And then the same principle should be applied to NetMagic. DOT should have themselves called those companies on which they have levied unnecessary demand, saying that we are going to issue a refund now. They should have done that on the definition of fairness. Anyway, friends, I thought I just wanted to put out this before the public domain so that people understand it. I hope that you understood this issue now. If you have any questions, please let me know in the comment section, and I'll come back to you with a new video later. Thank you very much.